Welcome back everybody to our studies in land law. This lesson is going to talk about the next process by which the acquisition of an easement may take place, this time through the process known as prescription of easements. Now, I would like to warn you to begin with that this is a particularly convoluted, complicated, and in my opinion quite stupid area of law that has some quite unfortunately worded legislation that makes it complex. So feel free to not feel too bad about not understanding it, not getting it straight away. We will go through it in a slow detail, as much detail as possible, at a slow pace. But for it, like I said, if there was some lessons that I did on trusts that had sort of similar elements of complexity to it, like the Van der Waal exception, for example, and I encouraged the students who were studying trusts to basically go, right, watch this a couple of times and don't feel bad if you don't understand it. Not all of law is easy, unfortunately. But this lesson is going to talk about prescription of easements, as I've mentioned. This is the final lesson that we're going to be doing on the ways in which easements are acquired, the acquisition of easements, and we will examine the niche circumstances in which an easement can be implied through the issuance of prescription. Now, implication through prescription is where an easement has existed for a long period of time and existed over a piece of land for a long period of time, but that there is no deeds or that there aren't any traces of the prescription. If that is the case, if it is sort of just like, well, we have this easement here and it seemingly has existed for ages, and nobody knows where it was originally cited, where it was originally written down, or where any trace of it, then if that is the case, then it may be implied that that easement exists. There are three main ways in which we can actually see the prescription of an easement. The first way is prescription through the common law. Secondly, we can talk about the fact that there may be the loss of a modern grant. And then finally, the unfortunate 1832 Prescription Act, which we're going to have to spend a little bit of time looking at. Just bear in mind, the Prescription Act, the wording of some of the legislation in the Prescription Act is so convoluted that even the courts have said it's poorly written. So there you go. That's and you know how terrible sometimes judges write. So imagine imagine how bad it must be if they think that it's poorly written. Okay, so bear that in mind. So these are the three ways in which we can see prescription occur. Beginning first then with the common law prescription of an easement. In order to show an easement by prescription under this first route, through the common law, it must be shown that it had the ability to be exercised since, quote, time immemorial. What does this mean? Well, essentially, time immemorial actually refers to a specific date. It refers to a specific time period. And the idea of time immemorial is supposed to be the ways in which we essentially date the point at which the common law begins. Now, the common law obviously developed quite slowly, but we would suggest that the ascension of Richard I to the throne in 1189 and the sort of Angevin Empire that was created is really in and around where the common law is created. Obviously, it has traditions all the way back into Anglo-Saxon legal systems. It has dates itself. It has little traces and touches from the Roman law, but we suggest here that from time immemorial is the time at which the common law begins, which is 1189. Okay, so in order to satisfy that an easement can be implied through prescription, it must be shown that it had the ability to be exercised since 1189. There can be a rebutting of the presumption where evidence is adduced to show that it cannot have been enjoyed since time immemorial. So obviously, the point here isn't to try and trace and go through the historical archives and find evidence that this easement was used in 1189, or it was enjoyed in 1189, or evidence that it even existed in 1189. The point here is to suggest that it could have been used in 1189. So, for example, an easement for light which came through a window that was built in the 1920s cannot be said to have been able to be exercised from time immemorial. If instead you had a farmstead, for example, that had sort of a field on one side, and maybe you had a right of access, you want to show that you have a right of access into that field, if you can show that this had existed from time immemorial, had the capability to exist from time immemorial, which of course you would probably be able to if those farms had sort of existed from that long, then you can maybe come to the assumption that this actually could be an easement which is prescribed in the common law. But yeah, things like an easement for light which comes through a window that was built in the 1920s does not count, because obviously that was an easement which would not be capable of being utilized prior to the 1920s, because that window didn't exist, because the building didn't exist. So that's how we sort of think about that. If you can show that it has been that the right has been enjoyed for 20 years, however, the rest of the time will be presumed unless that presumption can be rebutted. This is a very important point. So if you go into a court of law or go into a solicitor's office and they say, well, if you want to show a prescription through the common law, we have to show that this easement was able to be exercised since 1189. You might look a bit sheepish, and you might look a little bit blue at the idea of trying to do that. And so really, there is a presumption that is attached. So if you can show that the right has been enjoyed for 20 years, then it will be presumed that this easement could be enjoyed since time immemorial, unless that can be rebutted. So theoretically, okay, a window that was built in the 1920s, you could show that has been enjoyed for 20 years, and so there will be a presumption that it could exist from time immemorial. But then, of course, that presumption can be very easily rebutted by the fact that it was built in the 1920s, okay? But prior to that rebuttal, there is a presumption that it existed from time immemorial. It is only with the rebutting of that presumption, which obviously can very easily be done if you show that the house was built in the 1920s, that's when that happens. So really, the ways in which the ways in which prescription under the common law operates is actually quite nice for the person who wants to acquire the easement, because there is just a basic presumption of an exercise from time immemorial, so long as you can show that it has been enjoyed for at least 20 years. And then obviously it is up to other people to try and rebut that presumption by showing that either the building didn't exist, or that it was impossible that it could have been enjoyed from all that long ago. That's essentially how we do the common law granting of an easement. The second way in which we can do this is through the loss of a modern grant. If one can show the existence of the use of an easement for more than 20 years, then the courts could presume that there has been a grant of an easement that has been enjoyed in the past, but that has just been lost to time, okay? Again, this is another thing that is showing that they're quite nice for the people who are trying to acquire at least a formal acquisition of an easement. So if you can show, look, there's an easement here, and it's been used for more than 20 years, we don't have any documentation of where it was granted, we haven't got any documentation of some court order which implies it's granting or anything like that, but we can show here that it's been used for 20 years. The courts will respond and go, well, okay, if you can show that it has been used for more than 20 years, but you can't show me that there is any title deeds or any grant of that easement itself, then we will just presume that there has been a grant of that easement in the past and that just has been lost, okay? Now, the interesting thing here is no one can rebut this presumption by saying that no grant was ever made, essentially trying to prove a negative to suggest that there was no grant ever made. In order to rebut this presumption, you would have to show that a grant would have been impossible to have been made, okay? That is how you rebut the presumption, or alternatively, show a grant, theoretically show a grant which expressly denies the granting of this easement. But again, if you can't find a grant in the first place, then that won't be very possible either. Fundamentally, you have to show not that, look, there hasn't been a grant So therefore, we shouldn't give this. You shouldn't be able to presume and prescribe this easement, because then that is saying you're trying to prove a negative there. That would be impossible, and that would be a particularly low evidential standard. Instead, what you're going to have to do is say, right, no, the courts. I know you are presuming that there has to have been a grant in the past, but here's some evidence to show that this grant would have been impossible to be granted in the past, and so therefore we're going to rebut this presumption. Okay. Thirdly, then, and finally, the Prescription Act from 1832, the one I've been avoiding all this time. Okay, the Prescription Act, as I've read in here, and as I've said at multiple points, is difficult and complex, also poorly drafted, and is a pile of, a word I'm not going to say. Don't take my word for it, take the conclusions of the House of Lords in the case of Flight and Thomas. However, under this legislation, a number of things are indeed established. Firstly, if one can establish 20 or 40 years of uninterrupted use of an easement, it may be acquired by prescription. This is the case for all easements other than, with the exception of, easements of light. The two time periods, short and long, are able to be rebutted by either oral/written consent in the case of the short period, or just written consent in the case of the long period. The qualification of an interruption must be at least that of a year. And then if the easement is a right to light, which was obviously provided as an exception, it has to have been uninterrupted for 20 years. This will be taken as an absolute and indefensible easement. That is essentially the Prescription Act, okay? I'm not going to go into too much detail. If you want another lesson on the Prescription Act, in all seriousness, let me know in the comments down below, and I'll put another video unpacking the Prescription Act in a bit more detail if you really want. Again, the Prescriptions Act is convoluted, stupid, difficult to understand. Don't feel bad if you don't get it. I hate it too. So don't worry about it if you don't understand it necessarily. Notice here I've spent very little time talking about the Prescription Act. Often, in fact, the Prescription Act isn't really cited as many times anymore. It's quite an old, outdated piece of legislation. Obviously, that doesn't stop an examiner or a professor in land law giving you a problem question that requires you to engage with the Prescription Act. But at least in terms of the real world, it's probably not that likely that you're going to run into having to unpack and dig into the weeds of the Prescription Act. Especially given there's all these other express grants of easements, and there's all these other implied grants of easements, and then there's obviously the other types of prescription as well. But just bear that in mind when you are thinking about problem questions. Don't overlook it if you think it's particularly convoluted. Make sure you still obviously spend time revising and studying this topic as well. Welcome back, everybody, to our lessons in easements for land law. This is, in fact, our final lesson specifically on the acquisition of easements. And we're going to be talking briefly about the requirement for prescription of easements. So we noted in the previous lesson what prescription of easements essentially happens, how it happens, how it could happen, either through the common law, through the loss of a modern grant, or through the 1832 Prescriptions Act. Depending on which of these of the three modes of prescription one chooses to explore, there will be requirements which are necessary for you personally for all three. And this is really where we get to the requirements for prescription. In order for an easement to be granted through prescription, the user must be, firstly, as of right. They must, secondly, be continuous. They must be, thirdly, must be by or on behalf of a fee simple owner against another fee simple owner. And these are the three major requirements. Now, what do these things actually mean? What do we mean? What do you mean? I have to be as of right. I have to be continuous, and I have to be on behalf of or by a fee simple owner against another fee simple owner. What do all these things actually refer to? Well, let's begin with as of right. To show that the use of an easement is as of right, it must be shown that they are not users by force, by stealth, or without permission. Those are the three ways in which the three requirements that are satisfied for proving that you are as of right. The burden of proving this rests with the person who is claiming the right. I'm claiming that I have a right of grant of an easement or prescription of an easement, and as a result of which, in showing I have this right, I have to show that I'm not a user by force, by stealth, or without permission. So you have to prove that you are acting without force, you are acting without secrecy. Here, a reasonable person ought to be able to discover the existence and the exercising of that right. That's what we mean by secrecy or stealth. And then finally, the user must not depend on the permission or consent, whether this be oral or written. So these are the three requirements for the idea of establishing yourself as of right. We have three nice little Latin pieces of phraseology to sort of help us along our way in making a determination on this, and this is how we make this determination specifically. Secondly, we have to show that the right or the enjoyment is continuous. You must be able to show that your right has been continuously enjoyed. This is to be judged on the basis of what a reasonable person might consider to be continuous, might be considered to be continuous use or enjoyment of that right. That is the case as cited in the case of Mills and Silver. So fundamentally, what we're seeing here is a reasonable person test. Does a reasonable person acting reasonably with a reasonable basis of knowledge suggest here and know that you are continuously enjoying the right that you are seeking prescription of? This does not mean, however, that there is no opportunity for there to be breaks in the use of enjoyment. Continuous enjoyment isn't necessarily that strong of a phrase. It is just that on the whole, there is a mode of continuous enjoyment. So you can allow for there to be breaks in the enjoyment of the land, of the right, should I say, but it doesn't necessarily have to be continuous in the sense that it is always enjoyed, and even a break in that enjoyment for a day would mean that it breaks this idea of being able to grant a prescription. That's not essentially what happens. Finally then, the final requirement for you in proving and being able to essentially get an easement through prescription is you have to be by or on behalf of a fee simple against another fee simple. The claimants must show that they are either the fee simple owner of the dominant tenement, or that they are claiming the right on behalf of the fee simple owner of that dominant tenement. So, for example, if it is being claimed by the tenant of the property or something like that. Again, this is relatively uncontroversial. There's not much to be said about this. You have to either be the fee simple owner of the dominant tenement or claiming on behalf of the fee simple owner of that dominant tenement. Welcome back, everybody, to our lessons in land law. This is our final lesson on the subject of easements, focusing in this video on the concept of their termination and the process by which an easement can be terminated. It is the final lesson, as I mentioned. We're going to conclude by briefly running over the process by which easements are terminated. Some of these are very, very easy to understand. Some of them are a little bit more complicated, but generally speaking, it's a relatively simple and simplistic process. So there are generally three ways in which an easement can be terminated in law. Now, the three ways are as follows. You can see the termination by way of a merger. That is the first way in which a termination of an easement can take place. We can also have termination by way of release. And then finally, we have termination by way of change of character. Let's deal with the easiest one first, the idea of a merger. This is very, very, very simple, okay? If there is a merging of a dominant and a servient tenement, then there will be no longer the satisfied and the satisfaction for the requirements of an easement, and so therefore it will terminate. Remember back to previous lessons, in order for you to have an easement, you must have a dominant and servient tenement, and they must be separate. They must be owned separately as well. And so as a result of which, if you do not have this separate ownership, then you cannot obviously have an easement. And so as a result of which, if they merge, if they become one property, then, or they become under the remit and the ownership of one property, of one owner, then this means that they will terminate the easement. The second way in which we can terminate an easement is through the process known as release. Release can be done in one of three ways. You can release expressly, you can release impliedly, and you can release through statute. Okay, an express release will occur where their servient owner acts in a way in which suggests that they have been released from the burden of the easement. So, if you're the servient owner, you have acted in a way which suggests that you have been released from the burden of an easement. Therefore, there will be an express release of that easement and it will terminate. It can be implied where there is a lack of use of an easement for a long period of time. This is where we get something known as a presumption of abandonment. If the presumption of abandonment is made, it has to be obviously shown, it has to be presumed that an easement has therefore been terminated owing to the fact that there hasn't been any use of or enjoyment of the easement for a long period of time. And then finally, just like with the creation of easements, you can also terminate an easement under statute. This is done, which is on the basis of a number of different things. But one such example is, for example, the compulsory purchase order. A compulsory purchase order will, of course, terminate an easement if that would be a requirement in the purchase of that property. Simple as that. Finally, then, we have change of character. Change of character is a way in which we terminate an easement if there is a change of the use on the dominant tenement, which makes the servient tenement have an increased burden. Remember, the servient tenement is the one that is burdened by the easement. The dominant tenement is the one that is obviously enjoying the right of the easement. If there has been a situation in which the easement's change of character causes an increased burden on the servient tenement, then the easement cannot essentially accommodate that increased burden by reference to the fact that an easement is granted for a specific purpose. If that specific purpose changes, which then gives an increased burden onto the servient tenement, then this will also terminate the easement as well.